Thank you all again for being here. Good morning or good afternoon, wherever you're tuning in from. Keep dropping your location, your org, your name in the chat. It helps us know where folks are coming from. Next slide, please. I am Jasmine Ringel, as I mentioned before. I'm a senior associate here on the housing team at PolicyLink. Just a few housekeeping things before we get started. Please feel free to use the closed captions to better follow today's presentations if that helps your ability to learn. We recommend that you keep your view on speaker mode so that you know who is speaking at what time. Please be sure to use closed captioning if you need it. And most importantly, please be sure to drop your questions as you have them throughout today's presentations into the Q&A box so that we can all get to them. The session recording and slides will be shared with all of our registrants after the webinar. Next slide, please. So we have a lot of ground to cover today, but hopefully a lot of great ground. We're so excited to delve into how to activate HUD's latest fair housing guidance together, and especially with our guest speakers. Today, we'll be discussing and getting some context setting for what the issues are here, getting an overview of the fair housing guidance, digging deeper into some issues and latest research from our partners at Tech Equity and Upturn, and then finally close out with some reflections and suggestions on policy development and implementation. Next slide, please. And today we'll be hearing from Ariel Nelson and Chi-Chi Wu from the National Consumer Law Center, Hannah Holloway from Tech Equity. You're hearing from me, myself, Jasmine Ringel. We'll also be hearing from Marie-Claire Tran-Lung from the National Housing Law Project, Natasha Duarte from Upturn, Rashida Phillips, our Director of Housing here at PolicyLink, and Won-Young So from MIT. And without further ado, I'd love to pass it to Rashida to do some context setting for us here.
Good morning, everybody. Next slide, please. And you can go to the slide after that. Good morning, everybody. So I am going to just give us a little bit of context setting to talk about why we're here, why we're approaching this the way that we are, and how we're approaching it before I turn it over to our guest speakers. And there are three sort of frameworks, laws, and strategies that I want to highlight. And the first is housing as a human right. Housing as a human right affirms that every person, every individual is entitled to a permanent, safe, stable, and affordable home that is accessible to resources like grocery stores, jobs, and schools. Housing as a human right also frames housing as a fundamental necessity for dignity, security, and the pursuit of a thriving life. And when we look at international law, right, it does define housing as a human right. So it's not just, vibes, it's not just a tagline or a value. It is recognized in international law as housing that must be adequate, which consists of 7 elements: security of tenure, availability of services, affordability, accessibility, habitability, location, and cultural adequacy. So housing as a human right is just a really important framework and approach when we're thinking about things like tenant screening and access to housing. And again, you'll as our guest speakers talk about the different projects and approaches and research that is happening, you'll recognize, right, some of these frameworks and some of these approaches for how they're talking about it. And then there's fair housing. The fair housing is the law of the land. The Fair Housing Act of 1968 makes it illegal to discriminate in the sale or rental of housing or other housing-related activities such as seeking a mortgage or housing assistance. It protects people from discrimination on the basis of race, color, national origin, religion, sex, familial status, and disability. There have also been recent cases that have leveraged the Fair Housing Act in order to address issues of discrimination in tenant screening, in eviction records, and in other housing issues. So there's a case called Smith v. Wasatch Property Management, which was litigated by the ACLU, and it is a fair housing case based on eviction records and their disproportionate impact on Black women. And so that is a place where you can check out and do some reading to, again, see how fair housing is activated in issues like tenant screening and histories of eviction that prevent people from being able to access housing far into the future. And then the last framework that I will highlight is affirmatively furthering fair housing. So this is a rule, it's currently in place under it's called the interim final rule of AFFH, but it compels federal agencies and recipients of HUD funding to actively address housing discrimination and proactively foster equitable access to housing. And when I say AFFH is a rule, there is a specific rule for it, but the mandate to affirmatively further fair housing is embedded in the Fair Housing Act of 1968 that I just talked about. So it is a feature of the Fair Housing Act that federal agencies and recipients of federal funding have to actively address housing discrimination. It also requires that funds be used to undo systemic housing inequities that impact communities that are marginalized by race, disability, gender, or familial status. And so there's a requirement for jurisdictions who receive funding to do an analysis and to review priorities that can help advance resources and policies related to tenant screening. So the AFFH rule and the process that goes with it, such as the assessment of fair housing or analysis of impediments, does provide an opportunity to create and advance policies and priorities related to tenant screening. And again, you'll hear more about what that could look like in a few minutes. Next slide, please. So I just want to review, again, the reason why we are talking about this in the context of fair housing. And that is because, right, there are significant fair housing concerns that come along with tenant screening. And so criminal history records, right, there is a overrepresentation of Black, Latina, LGBTQIA+, and women in the carceral system. And more records equals more denials from housing. When housing providers and landlords utilize tenant screening companies and other technologies and things that call the histories of people, right? It typically includes these criminal records. And we know that there is not necessarily a correlation or a deep correlation between having a criminal history and your ability to be a good tenant or to meet the obligations of your tenancy. Right, so that false equivalency can often, it often results in people being locked out of housing. Then we know that algorithmic screening, products that are packaged that sometimes creates histories in formats that let landlords automate denials. So algorithmic screening that includes scoring, you know, that provides a score based on things that are not transparent, information that may be inaccurate, right? And so that poses significant fair housing concerns. Then we know that eviction records also pose fair housing concerns. I talked a little bit about that a few minutes ago, but we know that people with eviction records have a harder time accessing safe and affordable housing, regardless of the outcome of the case. And that these records are disproportionately filed against Black and Latina women and who are often head of households, and which often leads to substantial fair housing concerns, denials based on eviction records or eviction itself. And then landlords are frequently refusing to rent to prospective tenants if they have any eviction on their record, regardless, again, of the outcome of the case, or whether or not it actually led to an eviction. Those records themselves are often used in decision-making to prevent someone from having access to housing. And then a couple other places where we see it show up: source of income. Landlords and screening companies have and continue to deliver housing denials for people with vouchers or other sources of non-traditional income, which poses significant issues in terms of fair housing and discrimination. And we see in a few places that there are source of income discrimination laws that are put in place to prevent people from being able to discriminate against people with so-called alternative sources of income. However, these laws are difficult to enforce, difficult for people to engage with. And so it is really important that they be centered and contextualized within fair housing strategies and remedies as well. And then credit history. Again, various protected groups face systemic barriers to accessing lines of credit or financial opportunities that impact their credit scores. And you will hear much more about this from our experts on the panel today. Next slide, please. So there is good news, right? As we're thinking about all of the issues and problems that come with tenant screening, there have been significant advances over the past couple of years around these issues. And so we've seen in federal policy, the Office of Fair Housing and Equal Opportunity releasing guidance on the application of the Fair Housing Act to the screening of applicants for rental housing. So our next panelists will discuss that in more detail. And then we've seen culminating efforts by HUD and advocates across the country that built on the 2016 HUD guidance on criminal records. So we've seen a lot of fair chance at housing laws be advanced around the country. There was also a 2022 Biden-Harris administration blueprint for a renter bill of rights that came out, and many of the policies that were named or outlined in that renters bill of rights have been advanced in different ways. We also saw a 2023 CFPB, Consumer Financial Protection Bureau, and Federal Trade Commission requests for information on tenant screening. There have been significant CFPB bulletins that have come out, and then 2024 joint guidance from the Federal Trade Commission, Consumer Financial Protection Bureau, Department of Housing and Urban Development, and Department of Justice that helps tenants to navigate the application process. So again, you'll hear much more about these things from our panelists, and I will turn it back to Jasmine to move us forward.
Yeah, thank you so much, Rashida, for that thorough explanation of where we're at right now and how we got here and all of the issues that are intersecting in this area. But now I'm going to actually welcome Chi-Chi Wu and Ariel Nelson from the National Consumer Law Center to tell us a little bit more about the 2024 Fair Housing Guidance from HUD.
Thank you so much, Jasmine, for the introduction, and thank you to you, Rashida, PolicyLink, for having this webinar on leveraging the HUD's guidance for fair housing and inclusive tenant screening. It's really, next slide, please. It's really wonderful that you're holding this session and we're talking about this because this is an extremely helpful guidance. It really, we hope, has a huge impact on tenant screening and addressing some of the pitfalls and problems with tenant screening, especially for Black and Brown tenants. My colleague and I, Ariel Nelson, we are going to go over what this HUD guidance says and basically how it applies the Fair Housing Act's disparate impact test to all of the elements of tenant screening, which the main components being credit reports and scores, criminal records, and eviction filings. The guidance also discusses the implications of the use of machine learning and artificial intelligence by tenant screening agencies when they come out with scores or recommendations that many landlords rely upon and use to decide whether to accept or reject a tenant. Next slide, please. So the HUD guidance starts off with a description and overview of tenant screening, and then talks about the application of the Fair Housing Act. One of the things it makes clear is that the Fair Housing Act, FHA, applies not just to landlords, which it does, obviously, but to the tenant screening companies themselves when they are involved in the decision to approve or reject a tenant. The Fair Housing Act, as many of you know, there are two main types of discrimination, two standards under that act. There's the discriminatory intent standard or disparate treatment, which the guidance mentions, but really it focuses on the other kind of standard, the disparate impact standard. Many of you are probably familiar with this, but just in case, this is a 3-part test under the Fair Housing Act. When you have a policy or practice that is facially neutral, but when applied, has a disparate impact on a protected class, race, national origin, gender, etc. And that 3-part test says that if you have such a neutral policy that has a racially discriminatory effect, then that's the first prong. Does such a policy exist? The second prong is if such a policy exists, is the user of that policy, so the landlord or the tenant screening company, do they have a substantial, legitimate, non-discriminatory interest in having that policy? If so, then you go to the third part. Is there a less discriminatory alternative to achieve that non-discriminatory interest? So those 3 elements, that 3-part test, is really at the heart of what this guidance says, because it takes elements of tenant screening as well as tenant screening itself and says, if you look at those 3 prongs and you apply to tenant screening, what does that mean? Are these practices a potential violation of this disparate impact standard? And by the way, this is not discussed in the guidance, but it's super important to know. The Fair Housing Act does have private remedies. So it can be enforced not only by the federal and state governments, but by individuals who've been discriminated against. Next slide, please. I'm going to turn it over to Ariel at this point.
Great. Hello, everyone. Apologies for my voice. Please bear with me. So one thing that the HUD guidance does is not only describe how the law would be violated specifically, but also provide recommendations for landlords and also tenant screening companies. So some of the recommendations for landlords will probably not be surprising to you all, but in short, the HUD guidance recommends that landlords adopt clear, detailed, and publicly available screening products. And there's a real emphasis on how landlords should make sure to customize the screening product so that it's conforming to their actual policies instead of essentially what the tenant screening company is saying they should do, or this sort of off-the-shelf product. And along those same lines, it recommends that landlords make an independent determination based on their policies, even when the tenant screening report makes something like a denial recommendation. Many of you are probably familiar with how tenant screening reports these days often come with an accept or deny recommendation, a tenant screening score. The HUD guidance really urges landlords to make their own determination regardless of that part of the product. And I also just wanted to mention that it gives some guidance around what landlords should do when they're selecting a tenant screening company. And, it emphasizes again that they should find one that offers customizability. They frequently update their data, that they monitor for unjustified discriminatory effects. I don't want to list all of them, but that's just a few. I will say, in practice, that might be pretty difficult because tenant screening companies are marketing themselves a certain way. And they might say they do all these things, but there are some questions about whether they do. But HUD really lays out what you should be looking for in a, quote, good tenant screening company. And it also recommends that landlords provide applicants with the opportunity to dispute the accuracy or relevance of any negative information. And we'll return to some of these ideas around accuracy and relevance. Next slide, please. The recommendations for tenant screening companies, before I dive into exactly what these are, I do want to emphasize up front that the guidance clearly states that tenant screening companies can be held liable under the Fair Housing Act. That question has been litigated in at least 2 cases. And the HUD guidance acknowledges this and says that 2 courts have actually adopted their argument to find that in certain circumstances, tenant screening companies can be held liable. And HUD had actually weighed in one of these cases to say the same thing. So I think it's really good that they are making clear that just because you're a tenant screening company doesn't mean you can escape liability in this context. So in terms of the specific recommendations, it recommends they conduct civil rights monitoring, and refrain from providing denial recommendations or low grades in a conclusory fashion. And also, similar to the landlords, allow applicants to dispute whether a record should even be included, even when it's accurate, such as when an eviction is related to domestic violence. And again, there are some, we'll touch on this a little more, but there's some overlap here with obligations under the Fair Credit Reporting Act. So there's this sort of obligations related to accuracy and information. The other thing I just wanted to quickly emphasize along the lines of liability is, and I think that this shows how the HUD guidance is really speaking to what they've been seeing on the ground and what's been happening in litigation, is that HUD emphasized that the tenant screener can be held liable for facilitating a discriminatory decision, even if the housing provider makes the ultimate decision as a formal matter. So that's often a question that comes up. The tenant screening company says, oh, we had nothing to do with it. It was the housing provider. And the HUD guidance is really speaking to that situation. There's a lot of good detail in there, which I won't go into, but I highly recommend it. And the other thing I want to just mention about the tenant screening company's obligations is, you know, we've a lot of us have heard a lot about algorithms running wild. The companies are allowing them to do whatever they want. They're not monitoring them. And this type of civil rights monitoring that the HUD guidance is telling them to do is something that mortgage lenders and others do regularly when they're relying on complex models. So this shouldn't be out of reach for these companies at all. Next slide, please. And I will turn it back to Chi-Chi.
Thanks, Ariel. So there's a section of the HUD guidance that has overall recommendations, which would be applicable both to landlords and to tenant screening companies. And these tie back to the recommendations specifically for landlords and tenant screening companies that Ariel went over earlier. I mean, there's a theme here. So the HUD guidance says that tenant screening practices have to be relevant, which makes sense, right? If you're using a form of tenant screening where the criteria or the decisions are not relevant to determining whether someone is a good tenant, then you don't have that substantial, legitimate, non-discriminatory interest. Similarly, not only should the criteria and algorithms be relevant, but they should not be overbroad. And they should be tailored and individualized. And that's important because what this HUD guidance says and what just the disparate impact analysis requires is if you have policies or criteria that create racial or other protected class disparities, then the legitimate non-discriminatory interest to justify them does not exist if what you're doing is overbroad, if you're screening out good tenants along with what you're trying to screen the supposed bad ones. If you're so for example, if you have a tenant who is a voucher holder who has a guarantor for the rent, then something like a minimum income requirement should be waived because it needs to be tailored to the individual circumstances. Otherwise, you screen out folks for no reason because the voucher or the guarantor would have guaranteed the rent being paid. And your overbroad criteria is having this racially or other protected class disparate impact. Again, considering records where is not a negative income, like an eviction record where the tenant actually won the case, if you're using that to screen out tenants, you're screening out good tenants because there's been a court decision that they were justified. So overbroad criteria does not serve that legitimate non-discriminatory interest. So the criteria have to be tailored and individualized. Accuracy. I mean, this should be a no-brainer. If you have a tenant screening tool that gets the wrong person, gets the information wrong, you don't have a legitimate non-discriminatory interest because your data is bad. And not only is this a violation of the Fair Housing Act, but also the Fair Credit Reporting Act. The CFPB has issued several guidance documents on tenant screening or use of records and accuracy. And if it's inaccurate, you've got several laws that are implicated. Next slide, please. The HUD guidance also recommends transparency. And this part is probably more generally a recommendation as opposed to, a legal requirement tied to the Fair Housing Act. The guidance recommends that tenant screening policies should be in writing, public, and readily available, and that landlords provide denial letters, and such denial letters include as much detail as possible, including the reason for the denial, because oftentimes tenants will go apply for a unit and they'll just never hear back, let alone get a denial letter telling them why they were rejected. And so the HUD is saying that landlords should issue denial letters. And in fact, we at NCLC submitted a petition to the CFPB to try to mandate denial letters under a separate law called the Equal Credit Opportunity Act. That petition is before the CFPB, but we don't think it has great chances in the next administration. And then again, as Ariel mentioned later, disputes admitted, that the HUD is recommending that both the landlord and tenant screening companies account for disputes and mitigating factors to information. Next slide, please. So then the guidance pivots to the three main components of tenant screening: credit, eviction records, and criminal records. With respect to credit history, we at NCLC have been a big critic of the use of credit information tenant screening for years now, because we think, number one, credit scores were never designed to predict whether someone is a good tenant or not. They're only designed to predict whether someone is going to default or be seriously delinquent on a loan obligation in the next 2 years. Consumers treat rent versus credit obligations very differently. We all know the rent eats first. Consumers will pay rent before they pay their food bill, their medicine, let alone their credit cards. So the HUD basically says the same thing. Not designed for this purpose. There are no studies that show credit reports and scores are predictive. And we know there are huge racial disparities in credit scores. There's been like a dozen studies showing that Black consumers and Latinx consumers as a group have lower credit scores. And that has everything to do with the racial wealth gap and nothing to do with responsibility. It has to do with centuries of slavery and discrimination, which is shown in credit scores. But then when you use those credit scores to in tenant screening, you perpetuate those disparities. So HUD is sending up a strong red flag about the use of credit history in tenant screening. Next slide, and I'm going to turn it over to Ariel now.
The guidance next talks about eviction records, and it acknowledges up front that these are, one of the most commonly marketed elements of reports, and that they are now a standard feature, which just, I think, also speaks to the vast harm that they've had for so long on people's ability to get housing. And I know we're getting short on time, so Rashida really helpfully talked about eviction records too, but the guidance in brief, talks generally about the problems with the use of them, including how ambiguous information on how the case ended up, the disproportionate effect on Black and Latinx renters, women in particular, Black and Hispanic women in particular, families with children, people with disabilities. It also emphasizes that old, incomplete, and irrelevant eviction records shouldn't be used. It also talks about how applicants should not be denied based on proceedings where the tenant prevailed, there's a settlement, or the matter was dropped. It also talks about how eviction for non-payment of rent from a market rate unit shouldn't be relevant when an applicant has started receiving rental assistance. And it also says that it's problematic to rely on a past eviction that's been filed in retaliation for tenants asserting their rights. I think that last one is really important because we know that happens on a regular basis, and I think HUD is doing a good job of acknowledging the severe harm that happens when these records are used. And you can see the through line here, not just about discrimination, but also of relevancy. It's if someone if an eviction is really old, if someone won their case, why does that speak at all to someone's ability to be a successful tenant? Next slide, please. The guidance also talks about criminal records, and it really builds on the guidance that we heard about earlier from 2016 around criminal records. It emphasizes that justice-involved people are disproportionately people of color and people with disabilities. And it talks about how overbroad criminal record screenings are likely to have a discriminatory effect because of the disparities. It talks about what overbroad screenings look like, including the failure to differentiate between offenses based on things like their nature, their severity, how long ago they occurred. Also records that did not result in a conviction, and also that no opportunity to provide mitigating information. It also flags that when you're talking about applicants with disabilities, that a reasonable accommodation may be required. So, for example, a housing provider shouldn't be considering a criminal record if the individual now has a disability that makes it unlikely that they would ever reoffend. And I think this is speaking specifically to the case against CoreLogic that the National Housing Law Project and others have been litigating for a long time. And next slide, please. I'll turn it back to Chi-Chi.
Thank you, Ariel. So the HUD guidance also discusses the implications of the use of artificial intelligence and machine learning in tenant screening. Tenant screening companies often claim they use AI. First of all, we're not even actually sure that's true. You know, there is some question as whether they're really using these complex, powerful models, but let's say they are. The HUD guidance, notes FHA applies to housing decisions made using AI, and it says a couple of important things. First of all, if you have a model, it has to be interpretable. You have to be able to explain why the decision was made, because remember, if there's a discriminatory effect, if you don't know why a model made the decision, then you can't explain why there was a legitimate non-discriminatory interest. So models have to be explainable. They should be trained using demographically representative data, and they should be validated on a periodic basis to make sure they actually predict something. Because if you have a model and it's generating is signal, noise and not signal, then you don't have a legitimate non-discriminatory interest if the data coming out of the model is junk. And we don't know. We really haven't seen very compelling data that show that current tenant screening models are, in fact, predictive. So that is a big question out there. Next slide, please. And Ariel, finish it off.
Yeah, so we just wanted to flag some resources for you. Our digital library includes an article on this HUD guidance, as well as a rundown of a bunch of the CFPB related guidances that have to do with tenant screening. We also put out a series of legal treatises. They're behind a paywall, but I've linked them here. And then I wanted to list just a few cases that challenge tenant screening related things, including one case references the guidance now, and two of them are actually against tenant screening companies and not just housing providers. Thanks so much.
Thank you both so much, Chi-Chi and Ariel, for your wisdom and guidance. We already have the Q&A box popping with questions, so please feel free to address them while you're still here. But next, I want to invite Won-Young So and Hannah Holloway to talk about their latest research report on continuing issues and observations that they had in a survey that they conducted with landlords on their screening practices. So welcome, and thank you so much for being here, Won-Young and Hannah.
Thank you, Jasmine. I'll get us started, and I think that's actually a great segue based on Chi-Chi and Ariel's recent the review of the HUD guidance. You heard that it touches on advanced models, advanced technology, screening algorithms. We were really interested in both what that means and what that actually looks like and how it's showing up in today's rental system. So hi everyone, I'm Hannah Holloway. I work for an organization called Tech Equity. We address the role that the tech industry plays in two of the areas that most impact our lives, so in our housing and in our working conditions. And we've been landscaping the prop tech sector, or where we're seeing tech startups increasingly play a role in housing products and services. And for the research that we'll be sharing here today, we worked with Won-Young So, who is a PhD candidate at MIT, and his work focuses on the role that algorithms and AI play as drivers of housing inequality. Next slide, please. Yeah, so as I mentioned, we came together to really examine the role that technology is playing in rental application assessments. Just to do a little bit of level setting, I assume most of us on this call are familiar with traditional process of applying for rental housing. So an applicant will submit basic personal information, proof of income, references, consent for background checks. And historically, that consent for background checks, the landlord would pull credit, eviction, criminal histories. Historically, those histories and those reports were delivered directly to the landlord, who had to review them and come to some sort of their own conclusion about whether to approve or deny or, create certain conditions for the approval of that applicant. I think, as Chi-Chi and Ariel also mentioned, with the advent of credit scoring, we saw the introduction of this concept of compiling data into some sort of recommendation or some sort of different type of score. But until recently, those scores generally accompanied other actual information about that renter. It didn't completely replace it altogether. And now, with the introduction of technology into that process, what's sometimes called the raw data, which is just another way of saying the actual information about that applicant, the credit, eviction, criminal history, which also, as Chi-Chi and Ariel and Rashida mentioned, is rife with inaccuracies and inequities itself. Increasingly that information is not just provided to the landlord by these third-party companies, but actually those third-party companies are playing a role in assessing and judging that information themselves, and then providing a score or a recommendation about whether to approve to the landlord. So those assessments can be crunched using the actual tenant information, the raw data, but increasingly we're also seeing the introduction of information that has nothing to do with that applicant as well, to generate those scores and recommendations. So there's all sorts of different models, and as Chi-Chi mentioned, questions about the role that technology and sort of advanced machine learning is playing in that. But that's generally the world that we're talking about when we talk about algorithmic or AI tenant screening. Next slide, please. Yeah, and before we get into findings, I should also note both Won-Young and Tech Equity attempted to study this issue for a while by working directly with tenants. So we worked with legal aid partners to design surveys and ways for renters to tell us about their experiences in the rental application process and with technology specifically. The responses that we received were frankly lacking, because as folks on this call will know, the information that's shared with renters and with rental applicants is just, well, if there is any information at all, it's incredibly high level. So trying to understand the role that technology was playing by asking tenants themselves, without greater transparency requirements on landlords and on screening companies, became really challenging. But we came together to see if there was a way that we could survey landlords directly, and also pair that with a tenant survey for the sake of comparison. But earlier this year, we did that. We ran 2 surveys of both landlords and renters, and we focused on California and got 1,000 tenant responses and 400 landlord responses. And that's what we'll be talking about now. But I should note that we also are in the process of reviewing very similar survey results from Georgia and North Carolina. And the preliminary results from those surveys are showing kind of remarkably similar findings. So we think that this is indicative of the larger rental market. Okay, next. We can probably go to the next one from there. So for folks that are interested, the full survey sort of questionnaires are available in our report appendix, which we will link to as well. But for landlords, we were really interested in, what consumer reporting agencies, what tenant screening companies they were working with, what they received from them, and how they used it. We'll come back to this later in the presentation too, but much of our analysis really focused on the landlord responses because, as a spoiler, there was still very little information that renters could provide about the role of technology in determining their rental outcomes. But on the landlord side, I do think it's interesting to look at the top companies that were providing screening results to them. So you'll see here that 4 of the 5 most widely used screening tools offer some sort of proprietary recommendation, some sort of their own adjudicated score to landlords. So Zillow's rental manager service is the only one here that does not rely on AI tenant screening or proprietary recommendations or risk scores. For the rest of these, TransUnion, Experian, RentGrow, Yardi, and eRenter, there are sub-services within them, but all 4 of these options have some sort of risk analysis or grading that they're offering to landlords. So it emerged fairly quickly that automated screening or rental recommendation software is fairly widely used amongst the landlords that we surveyed. Next slide, please. And that really bore out in the rest of our research as well. So only 59% of landlords reported receiving the actual tenant reports, the sort of underlying tenant reports on the applicant themselves. So for this particular question, landlords could select from multiple responses, assuming that they might receive the underlying report and a risk score and use those together. So we thought there would be some meaningful disaggregation that we should do with that. And when we did that, we received that, or we saw that landlords who are only receiving one type of screening result, for that, there are 34% that are receiving only the underlying reports. So what we might think of as again, information on the actual applicant themselves. On the flip side of that, 28% of landlords are receiving only a recommendation and 10% are receiving only a risk score. So together, there are 38% of landlords that we surveyed that are receiving no actual individual data on the applicant themselves. Next slide, please. Yeah, I think the type of information received is also important here. So you'll see it's down at the bottom, but 1 in 5 landlords reported receiving predictive information from screening companies. This is clearly the least commonly reported type of information that landlords received, but still it's 20%, 1 in 5 landlords is receiving that. And this is sort of based on aggregated, unproven predictions about an applicant's behavior in the future. Next slide, please. Yeah, so just to dig into this a little bit more, these are the types of analytics that might give a landlord, say, a prediction, supposedly a prediction, about how likely a potential renter is to pay the rent late or to break their lease early or to damage a property. Now, we don't know what actually goes into those predictions. We can't say if it's accurate or even if there's any sort of verification of the data that they're using. And I also want to note that this sort of predictive analysis, which judges people based on actions they've not yet taken, is sometimes called social scoring in other contexts and was actually recently banned in the European I can't say that, the EU, let's go with that, the EU in their recent AI Act. Next slide, please. Yeah, so in addition to what landlords are receiving, we also wanted to understand what they're doing with it, right? It's one thing to get this type of information, but how are you applying it to the actual person in front of you who's seeking rental housing? So we asked landlord respondents how they're using it. Are they just following what the screening results tell them to do? Are they weighing it with their own sort of considerations? And across the landlord sample, there were 37% of respondents who are just following the third-party recommendations outright. They're not really applying their own judgment. They're just saying it says renter approve, or it's giving me a score out of 100 that's 80, so I'm going to approve, or I'm in the yellow zone, so I'm going to approve with conditions. They're just sort of doing what it tells them to do. So the flip side of that is 60% do review the results or apply some level of discretion. But as we've been talking about here today, and as I think folks on the call will sort of intuit, these are pretty concerning figures, especially taken in context with the 2016 and the 2024 HUD guidances that are calling for a greater level of discretion in landlord decision making and not really relying on these types of scores and recommendations from private companies. And applied across the California market, which is where we conducted this research, this could mean that as many as 2 million, over 2 million renter households are assessed in ways that create risks and may not be compliant with the Fair Housing Act. Next slide, please. Yeah, the survey also found the highest prevalence of landlords who are relying on AI or technology among small landlords or mom and pop landlords. So when we isolated the screening practices of landlords by their portfolio size, those in the 1 to 4 unit category increased as a total share of those who are just applying the tenant screening recommendations outright without additional analysis or discretion. So landlords operating in the 1 to 4 unit category were 57% of the total sample, but bump up to 62 of those who are just relying on the results. Next slide, please. Yeah, I also want to pull out that landlords who were charging lower rents are also more likely to rely on algorithmic recommendations or risk scores than landlords overall. So again, in the total sample, there were 37% of landlords who just applied the screening recommendations outright. And then when you isolate that down to how different landlord groups answered that question, the largest deviation or sort of change from that 37% was amongst landlords charging rents affordable in the 0 to 30% AMI category across the state. So then reliance on screening results bumps up to 40% for those landlords. So I think that I wanted to pull those out because I think where in California, where this survey took place, there are, as I'm sure in many of the contexts that you all work in, exemptions for mom and pop or smaller landlords in much of our renter protections. So we're seeing that the reliance of these untested, unproven models by this group means that newer technology is being disproportionately deployed on renter populations with comparatively fewer protections. So I think all of these findings, the prevalence in the market where we're seeing it sort of disproportionately applied to renters who are in often the most vulnerable positions kind of makes a lot of what we found, or rather didn't find, on the tenant side of the survey all the more concerning. And so for that, I'll pass to Won Young to go over that.
Thanks, Hannah, for the lender survey result share. So my name is Won Young, and I'm happy to share the tenant responses and then also the implications regarding the HUD's recent guidance about the tenants fair housing laws and then on the tenant screening practices. So for the tenant responses, as Hannah just mentioned, that it's a little bit there are almost little to no about how this kind of algorithmic tenant screening impacts their tenancy, but then we just want to underscore this racialized impact of how this unproven screening technology is actually influencing over renters' access to housing. So this graph basically shows that the Black and Latinx renters in California were almost half as likely to have their renter applications accepted compared to white renters. So for the 46% for the Black renters and then 43% for Latinx renters. So what we're seeing is the kind of the overrepresentation of Black and Latinx renters among denied applications, along with the significant impact on landlord with the small portfolios and those serving renters with the lower area median income, as we just saw. So this basically suggests that the tenant screening in algorithmic context is having a disproportionate effect on vulnerable renters who already have fewer housing options and legal protections. While our research doesn't establish a causal effect between automated tenant screening and the racial disparity in the rental market, but the survey do make one thing very clear, that the racial bias is deeply embedded in rental housing. And with the growing use of the technology, there's a really real concern that it's helping to scale these existing inequities in the rental market. Next slide, please. And this is really concerning finding of our study, if not the most important. So only 3% of the renters could name their screening or consumer reporting agency involved in their screening process. Rather, in many cases, they only identify their landlord or property management company instead of their actual consumer reporting or agency or tenant screening company name. And then the implication is very clear that even if renters want to correct inaccuracies in their records, it's nearly impossible because they don't know who to ask, and then they don't know anything about the actual company who provide this report. So in fact, the request that Tech Equity made to the California Civil Rights Department revealed a surge in housing complaint involving the term score starting in 2018 and continuing through the 2023. And what's striking is that there was zero score term shown in the housing complaint in the 5 years prior to 2018. So it really highlights that how the recent trend of algorithmic scoring for tenants affect access to housing. Next slide, please. So then this raises a really important question that how can renters enforce their rights if they don't even know who's screening them or how this process works. So these companies are collecting a lot of data on renters, but the renters, their advocate and even landlords are often left in the dark about what's really happening behind the scenes. So we actually have the protections in place, like all the Fair Housing Act and the Fair Credit Reporting Act. But if renters don't know all the parties involved in the decision making, they're already at a disadvantage when it comes to enforcing their rights. And even difficult thing is that renters who wants to get a copy of the tenant screening from the tenant screening company, it's also impossible because they don't know anything about the information. So this lack of transparency allows discrimination to go unnoticed, and then leaving renters to deal with the consequences of a system that isn't working for them. Next slide, please. So to conclude our presentation, we'd like to raise a discussion point from our findings, especially with regards to the HUD guidance. So as we all seen, the HUD released guidance on applying the Fair Housing Act to tenant screening practices. And then one of the core recommendation was that housing providers should establish this clear, transparent screening criteria. And I think in general, it's really great recommendation. But there are something to consider as well. And then this guidance essentially calls for a shift away from the black box algorithms and encouraging landlord to assess tenant with the assistant from rather than the relying solely on automated tools. But let's think about the motivation for using these tenant screening services, both small and large scale landlords. It is to automate their decision and to outsource their decision. And I think that this motivation essentially contrasts with the HUD recommendation to return to individual review. And especially based on our finding, mom and pop landlords may face more challenges in developing clear non-discriminatory screening criteria because there's no specific guidance about how to create this. And in the next slide, the issue actually ties into the problem of the default values. So this slide shows the one screening company's screening criteria for the prediction and then opening some possibility for landlord customizing it. But we need to actually think about all the customization started from the default value provided by the tenant screening company. So if each tenant screening services provide this default screening criteria, then there's a high risk that many landlords, especially the small scale landlord, adopt this default with only minimal customization, if not just adopt without any customization. So this really highlights the need to regulate these default values, and as they shape the screening criteria offered by companies, but potentially minimally tailored by landlords. And I think that the HUD guidance does not really delve into the specific parameters that is displayed on the screening criteria document, and also less about what default should look like. So I think to ensure the non-discrimination, we must consider how each criterion is connected to the deep-rooted inequalities that have long affected housing inequality in the U.S. Yeah, so that's it. That's our presentation. As Hannah shared briefly, we are working on the survey analysis to other states. So stay tuned. And then in the next slide, we have our email address. So please keep me in touch. And then that's our presentation, and we love to hear your feedback and questions. Thank you.
Thank you so much, Wanyang and Hannah, for, I think Rashida noted in the chat, the very sobering, but informative and really important research that you all did for advancing the field and advancing the policies that we pursue. Next, I want to invite Natasha Duarte from Upturn to talk to us about some policy solutions that we might want to be a little wary of when it comes to this work. So thank you so much, Natasha, for being here. I will kick it off to you.
Thanks, Jasmine. I'm going to give a pretty quick overview of Upturn's issue brief on portable tenant screening reports. There's a lot more detail in the report. Unfortunately, I have to go as soon as I'm done talking, but I'm putting my email in the chat. Please feel free to reach out if you have questions or want to talk about this more. Okay, thank you. So rental application fees, as a lot of y'all probably know, are a huge burden that can make just searching for housing unaffordable. Fees disproportionately impact Black and Latina renters, renters with criminal and eviction records, voucher recipients, and others who face discrimination in the housing application process. Next slide. In several states, portable tenant screening report legislation, and terminology note, portable and reusable tenant screening reports are often used interchangeably here. This kind of legislation has been proposed or passed in several states to try to address the problem of application fees. The idea is that a renter could purchase just one report to reuse throughout their housing search. Unfortunately, when we started looking closely at these laws and at the reusable reports available on the market, we found that this system is problematic in several ways, which I will touch on. Next slide, please. So first, it's too easy for landlords to avoid accepting portable tenant screening reports when tenants try to use them. About half of the existing laws and many of the proposed laws make it optional for the landlords. They can decide whether they allow tenants to, or they will waive application fees and allow tenants to use portable tenant screening reports. Other laws have loopholes, exceptions, or burdensome requirements that allow landlords to reject reports when tenants try to use them. Tenants also have no guidance and are confused about how to obtain portable tenant screening reports. Message boards, news reports, and conversations with state advocates have revealed that many tenants have been unable to use these reports. Tenants who know about the law can't figure out where they can purchase a report that meets the law's requirements. And some tenants have reported that they tried to purchase a report and were unable to get the landlord to accept it. Next slide. The laws place burdensome conditions on tenants seeking to use portable reports. For example, the laws often require that that applicants certify that the information in the report hasn't changed in the last 30 days. As you probably know, consumer reports, like including tenant screening reports, are notorious for often having inaccurate information, and it's really unclear how the applicant themselves would be in the position to certify that if the landlord pulled a new report within 30 days, that there wouldn't be different information on it. And this requirement seems really unnecessary because most of the time these reports are only good for 30 days anyway, so that should be enough like insurance for the landlord to know that it's an up-to-date report. So this requirement puts tenants further at the mercy of tenant screening companies, which are notorious for reporting inaccurate information. The reusable reports available for purchase don't necessarily align with state laws. For example, the law in Maryland requires portable tenant screening reports to include all federal, state, and local charges against and convictions of the prospective tenant over the previous 7 years, and a comprehensive eviction history for all state and local jurisdictions going back 7 years for each jurisdiction the tenant has lived in, regardless of whether that residence is reported by the tenant or on a consumer report. So pretty specific, broad requirements, problematically broad, which I'll talk about in a few minutes. But the point here is that if you, the screenshot here is the portable tenant screening reports that you can buy from My Screening Report, and they describe the contents in very general terms: eviction search, criminal search. So that doesn't give an applicant the kind of detail that they would need to determine whether these reports would actually meet their state law's requirements and therefore require the landlord they're applying to accept the report. Next slide. Landlords remain in control of when and where tenants can purchase reports, given what is currently available on the market in terms of portable reports. So most portable tenant screening report vendors require, if you want to buy a report from them, you actually have to get an invitation from the landlord you're applying to for the company to then send them a report. Some of them don't explain how you're supposed to get this invitation. Some of them provide a form for you to fill out that will then send the landlord an email prompting them to send you an invitation. But that means that you can't just order a portable tenant screening report from most companies before you even start your housing search and then just send it to whoever you want, whenever you want. Even after you get an invitation and purchase the initial report, often they still require any subsequent landlords you send it to send you an invitation. So you have to try to ask each subsequent landlord to invite you to then submit the same report that you already paid for to actually get this benefit of only paying once. Portable tenant screening reports don't actually eliminate fees as a barrier to housing because you still have to buy reports. The cost of a portable tenant screening report ranges from about $35 to about $65, and they're typically only good for 30 days. So people whose housing searches take longer than 30 days, which is often the case for people who are using vouchers, people with criminal and eviction records, and other things in their background, or other protected classes often who face rejection, discriminatory rejection when they're doing their housing search, often have housing searches that stretch on much longer than 30 days. And that might require you to buy more than one portable tenant screening report. So the cost can still really add up, and there is potential to save money compared to paying a separate fee for every unit you apply to. But it's still not really fair to call this affordable. Next slide. Finally, portable tenant screening report laws risk further entrenching discriminatory tenant screening criteria. So all of the portable tenant screening report laws require some combination of criminal, eviction, and credit history reports to be part of the portable report. And all of these records reflect disparities based on race and other protected classes and reproduce housing discrimination. So that's why I say they further entrench housing discrimination by enshrining into law that in order to apply for housing and take advantage of this exception to paying all these fees, you have to have a report that has these things in it. Some of these laws requirements are very broad. The Maryland criminal background check law that I was just talking about, or criminal background check requirement I was just talking about, as well as the eviction requirement, is very broad and likely conflicts with the HUD tenant screening guidance that that was just talked about in this webinar. And in other cases may conflict with local tenant screening laws. These portable tenant screening report laws also further entrench unreliable and exploitative tenant screening companies. Instead of trying to make it easier for tenants to apply and qualify for housing, these tenant screening companies who really are just trying to get their piece of the money that is extracted from tenants in the rental housing market, who regularly report inaccurate information and are often not responsive to tenants' requests to correct information, these laws are kind of saying, you know, we're enshrining tenants and landlords' reliance on these companies for the process of making every decision about who gets access to rental housing. Next slide. So for all these reasons, we recommend focusing on banning application fees altogether, as well as curtailing tenant screening, rather than focusing on portable tenant screening reports. Vermont and Massachusetts have passed legislation prohibiting rental application fees. These laws aren't perfect, but and so we do talk about what could be improved upon. For example, only one of the laws explicitly bans application fees. The other sort of does so by omission, saying, you know, you can only charge this list of fees and just not including rental application fees. It would be better to explicitly ban rental application fees of all types in all situations. And these laws need to apply to all actors that might charge a fee, including brokers. And I think it's Massachusetts doesn't explicitly apply to brokers. And so real estate brokers have gotten away with charging rental application fees, and they need to include strong proactive enforcement. Next slide. Finally, while we don't, our recommendation after looking into these laws is that they should not be the priority. There are better ways to protect tenants, but we also appreciate that in some jurisdictions, advocates might be in the position of, you know, not having made been able to make any political headway on straightforward bans of application fees or restrictions on tenant screening, and may feel or make the judgment that you know, a portable tenant screening report law is moving and it would be better to try to make it better than to oppose it. If that is the case and that's your judgment in your jurisdiction, we do provide some ideas for ways to try to amend these proposals that could make them stronger and more effective. And I won't go over each one of these, but this list is basically our recommendations, which we go into more depth on in the report. So yeah, I will stop there. And again, happy to talk to folks later. Please reach out to me if you want to chat about this. Thanks.
Thank you so much, Natasha, and thank you for this report. I believe it was shared in the chat, and also Natasha's email as well if you have any follow-up questions, because we have to respect her time and she's got to skedaddle. But next, we're going to turn to Marie-Claire Tran-Lung from the National Housing Law Project to talk to us a little bit about, you know, we've heard a lot today, but where do we go from here? What options are available to us to develop policy or to change our practices? So thank you so much, Marie-Claire, for being here, and I'll pass it over to you.
Great, thank you. Thanks PolicyLink for putting this together, and it's always great to be on a panel with everyone here doing such great work together. So we can move to the next slide. So today I'm tasked with talking to you all about policy development and implementation, and we're gonna kind of rewind a little bit to see what happened with HUD's 2016 criminal records guidance that's been referenced a few times today. Back in 2016, HUD issued criminal history guidance. There are some similarities to the 2024 guidance that is the subject of today's webinar. Number one, they're both really documents that provide HUD's legal analysis of screening practices under the Fair Housing Act, and that go through theories of liability and for intentional discrimination and then unjustified discriminatory effect. In that way, it's not necessarily like a new rule or regulation. It's really HUD going through legal analysis. And I think that's something that will be important as we kind of go into this next administration. And it also offers best practices to ensure fair housing compliances. So those are kind of the two like top level similarities between both of them, both of the guidances, which is why I think what happened with the 2016 guidance can be relevant to what happens now in terms of implementation of the 2024 guidance. And then just to make sure we flag like the differences, the 2016 guidance really focused on housing providers, whereas the current guidance, the 2024 guidance looks also at the tenant screening companies that we spent a lot of time with today. And then the 2016 guidance was very limited, to criminal history and actually also theories of race discrimination, did not go as much into issues of disability status. The 24 guidance covers criminal history and includes that reasonable accommodations discussion, goes into eviction history and credit history. And I think those are also examples, and that it doesn't need to be confined to those three. Next slide, please. So, you know, I don't remember when this webinar was first announced, but in the last few weeks, we've all had to think a little bit about what is going to happen in the upcoming administration. So I thought it would be good to spend a little bit of time here talking about what happened with the first administration. So HUD had released that guidance in April of 2016, and then Trump came into office about a year later. We were nervous that HUD was going to rescind it, but HUD did not. And I think it most likely fell a little bit under the radar is my guess. I don't think that was a policy stance at all. But we still operated like it could go away at any minute. And so during that time, a lot of state and local advocates really fought for protections for people with criminal records, and created a lot of great policy that I'll go into detail about. Sometimes folks relied on the guidance, but sometimes they didn't. But what the guidance did was help to create this this momentum for this work. And it was really the state and local advocates that really helped to pave the way during that time for some progress that we would see under the Biden administration. And you know, some of that tinkering with like what language looks like in ordinances or what sort of enforcement mechanisms that could happen at the state and local level became very important later as HUD was trying to figure out some policies to help people with records. And so there's two things, there's several things, but two things I wanted to flag as progress under the Biden administration. One was that they did finalize a rule earlier this year that would allow people with criminal histories to become fair housing testers. Before then, you know, a person could not with a conviction couldn't be a tester, which was very difficult in these situations. And so that was progress. The other thing is that there was a proposed rule on the use of criminal history in HUD assisted housing that was, there was a notice and comment period early this year. And it had very positive policies in there. It is still like in the kind of bureaucracy of HUD. And I think at the end of this presentation, I'll share a sign-on letter that folks within the Partnership for Just Housing have put together they're collecting sign-ons to today for asking HUD to release that. But the main takeaway here is that the work to implement this guidance is very, very important, both for making sure that you see things happen in, you know, that can impact people's lives at the state and local level, and for momentum when there's opportunities to change it at the federal level. So next slide, please. So what I'm going to talk about are actions for implementation. And there's quite a few actually, and this was actually a really great exercise for me to remind myself like all the progress that was made in those 4 years. So one, I think for advocates and policymakers, it is so important to understand like the scope of the problem. And today we've had like really great presenters talk about the research that they've done. And also we can all engage in some of that research ourselves, especially at the local level. So for example, fair housing testing, there was quite a bit of fair housing testing around the use of criminal records after the guidance came out. What is now known as the Louisiana Fair Housing Action Center created an influential report that is still really important today, where they did testing and they reported on the disparities, and it has led to a lot of changes. And I think organizations could do that. Also, after the guidance was issued, the Washington State Attorney General, their office engaged in fair housing testing and saw that there was a lot of practices by landlords where they were denying, for example, Black applicants, even though they had the same records as white applicants. And that in and of itself is very powerful because all of that data together helps to, again, bring a lot of attention to this issue and show how necessary it is for state and local policymakers to deal with it. The second area for implementation is really outreach and education. You know, all of us here know about this guidance, but there are so many people out there that don't and that need to understand more. And so PolicyLink bringing us together is like a fabulous first step. So, and the audience matters. So the audience includes the policymakers, but it also includes housing providers, tenant screening companies, and industry groups. And there are forums for that where it can be really helpful from a compliance standpoint. There's also tenants who you know would benefit from understanding this information and how it impacts them. And then another group that we often work with are fair housing groups who can enforce and test for these laws, legal service providers who might see these come in the door and refer them out, and then other service providers. So for example, like reentry service providers or housing counselors or other groups where it's really important that they sort of understand some of the issues that might walk through the door. Next slide, please. One very fruitful area is administrative advocacy to change admission policies. There are so many admissions policies out there, and especially given the various federally subsidized housing programs. And we have worked with advocates who try to get their in public housing, just tried to do advocacy to their public housing authority to change the policy in public housing, to change administrative plans around the Housing Choice Voucher Program, and to also work with owners around project-based Section 8 tenant selection plans. And each of these matter. They matter. It can feel like there's it's a lot of groundwork for a limited jurisdiction. But one like through line is that in the HUD, in the regulation that they have proposed now, one of the things they really wanted to see was have public housing authorities incorporated some of these best practices around admissions. And so the work that local advocates do to change their public housing authority can then create momentum for HUD later to create rules that apply to all the housing authorities. So that's one area, and that's really focused sort of at the local level. At the state level, there's also a really great opportunity. Low-income housing tax credits. They have qualified allocation plans that can talk about admissions policies there. And we have found that state housing finance agencies can sometimes be quite amenable to these type of policies. We've had a lot of successes in the criminal history space. And there might be very state-specific programs where, is there an statewide admission policy that you want to influence there? Or if you have state fair housing entities, could they issue similar guidance that builds off the HUD guidance? So, what we're trying to do is to take this very great document that HUD has provided and then infiltrate it in as many places as possible so that, if for some reason, it does get rescinded, there are other authorities to look to. Next slide, please. And then there's legislative advocacy. That is what we've really seen here is some state level laws change, like in New Jersey, which is a big leader in this space, and then also local ordinances. It's a wide variety of local ordinances. And I'm not going to get into all of it today because there's just not a whole lot of time. But if you are considering this, I think there's a lot of things to consider. One is, do you want to do a standalone bill around, for example, criminal or eviction records, or do you want to tie it to fair housing? That's a coalition question. These laws can talk about process, like how many days and what kind of information are you supposed to give. And they can also talk about substance, like what can you not use as part of the screening process. There are potential First Amendment issues if you try to say that landlords can't ask questions about certain things. So I just want to raise that flag for folks. And then the key thing, I think, is that for the criminal records work, coalitions with directly impacted leaders have had much greater impact than those without. And I am very confident that this is the same in any of the work that we're doing as well. So something really to keep in mind. And then the next slide is my last one, and I'll go through these really quickly. One is, this is kind of a little bit of a hodgepodge of different things. One is affirmatively furthering fair housing. That's one of the frameworks that Rashida went over today. At the federal level, it's a little bit at limbo, but in California, we do have our own state AFFH requirements, and that I think could be a potential area to deploy the guidance. And to the extent that states are thinking about similar mechanisms, this can be really helpful. There's also potential state regulatory advocacy. So if your state has fair housing regulations or is considering it, you could bring some of these tenant screening principles there as well. California has a fair housing regulation that deals with the use of criminal history. That is very good and also modeled after the 2016 guidance. And of course, like I am in California, but I very much recognize there are other scenarios out there, especially for red states. We have worked with I guess the blue dots in the red states that have looked for some creative ways to implement guidance. So for example, in Austin, there was work there to try to get admissions like incentives as part of a bond that for folks who are interested, we can go into more detail. I can talk to folks offline. And then the last thing that I'll mention is that the guidance can be where the guidance is probably most like it can be helpful is around affirmative litigation. And there were quite a number of cases after the 2016 guidance that were filed to try to make sure that we could enshrine some of those principles into case law, which is really, really important, but also extremely high level litigation. So what I just want to say is, if you are considering this, consult with fair housing experts, especially for federal court, because the makeup of the courts are much different now than they even were 8 years ago. So make sure that you consult with folks. And if you're not sure who to consult with, let us know. We can point you to the directions of the right people. And also in state court, there are friendly civil rights or consumer agencies may be really good partners and maybe perhaps like an attractive alternative to federal courts, depending on what your situation is in your state. So hopefully this is like positive after what we might be facing over the next few years. Like there's so much that can be done with this guidance, and I'm very excited to see what folks do to implement this at their state and local level. Thank you.
Thank you so much, Marie Claire, and thank you so much to all of our presenters. Next slide, please. I'm just going to close us out by sharing some resources that were already shared in the chat. And again, just to encourage us, we're seeing these policies gain traction. So PolicyLink maintains a map, all of our presenters have resources on these things that we'll share again in the chat. But just be encouraged, right? We're seeing the emergence and spreading of eviction record sealing, criminal records, fair chance housing policies, tenant screening policies that are gaining traction, some of which were shared by our presenters. And you can explore on this map. There's links to these policies so you can look, compare, and contrast, think about what you can bring to your own community. And then next slide, please. We would love for you all to stay in touch, to stay engaged, to continue to take action. I know all of our presenters are open and happy to continue, and sorry if you're not, but I am volunteering you to continue discussing and sharing resources with folks and being sources of information. And all of these folks have been really key partners and thought leaders and collaborators. And for me personally, utilizing them to support advancing tenant screening policies and eviction record policies in Pennsylvania and in Philadelphia, where I'm from. And so I know that they can also be an amazing resource to you as well. So stay in touch. We're going to have some more events and things coming up next year, and reach out to us if you need anything. Thank you.